Any joint venture involves somehow limiting each participant's ability to compete against the other. But does that mean every such agreement violates antitrust? The court in Polk Brothers Incorporated versus Forest City Enterprises Incorporated considered that question. Polk Brothers primarily sold appliances and home furnishings. Forest City sold building materials, construction equipment, and tools. In 1972, the two businesses made an agreement that Polk would build a single large building in which both businesses would open stores. Between them, the businesses offered a full line of goods for building, renovating, maintaining, and furnishing homes. And to minimize overlap between their product offerings, Forest City promised not to sell major appliances and furniture, with a few exceptions. Polk promised not to sell a whole line of building and gardening materials. Forest City leased its part of the building with an option to buy, which it exercised 3 years later. At that time, the two firms agreed that the lease restrictions would become covenants running with the land for 50 years. Several years later, Forest City's management changed and sought to end the noncompete agreement. Polk declined. Forest City then informed Polk that Forest City considered the covenant invalid. Polk sued Forest City in an Illinois state court. Forest City removed the case to federal court. Forest City then began selling home appliances in violation of the noncompete agreement. Polk sought an emergency injunction compelling Forest City to honor the noncompete agreement. The district court magistrate recommended granting relief, but the district court judge denied Polk's motion, holding that the noncompete covenant was an essential part of the joint venture, not just an ancillary part of it. The court concluded that the noncompete agreement violated Illinois' antitrust law. Polk appealed to the Seventh Circuit.